I guess I will talk about it for a minute. The difference between first and second degree, and you're asking that I submit second degree, and it's in the instruction itself, on the bottom of, I don't want to say bottom because I don't have them displayed as they would on the page, but on instruction, the instruction you requested, which is 1022. Under the heading difference between first and second degree reckless homicide, it says the difference between first and second degree reckless homicide is that the first degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Then of course the standard for submitting the lesser is that there's ground in the evidence to acquit on the greater and still convict on the lesser. Where's the absence of evidence of utter disregard for human life?
There's a line of questioning on the cross-examination of the defendant in which Attorney Binger asked, I believe in regards to each person shot or shot at, except for that of Mr. McGinnis, I suppose. If the defendant, I can't remember the exact wording, but if he even cared if he killed the person alluded to. So I believe that the defendant denied that he said he had to shoot him. He denied that he did not care about their life. So I believe the jury could find, based on that line of questioning, as well as just the evidence in general, that the defendant did not have an utter disregard for human life, as he testified. He testified that he essentially had regard for human life because he felt he had to do it, and he didn't really want to kill anyone.
Well, let's hear from the defense.
Element 3 is the circumstances of the conduct showed the utter disregard for human life. And in terms of the evidence in the case, I think the testimony was he didn't want to have to do it, but he did it to defend himself. So, as I said in our instructions, I don't think that there has been any evidence offered which would support the lesser included on count 1. So I would ask the court give 1020, which is the first degree reckless homicide charge, along with the self-defense instruction, and that'd be that. Because I think that's what the evidence shows.
I'm going to do a colloquy with your client when we get done with all this. Don't let me forget, please.
I've discussed it with him.
Yeah, but I got to talk to the person. The instruction says, in determining whether the circumstances of the conduct, and that's a correct point, the conduct showed utter disregard for human life, consider these factors: what the defendant was doing. He was firing a gun into, let's see, this is count 1, so we're talking about Mr. Rosenbaum. He was firing a firearm 4 times into a human being with fatal consequences. Why he was engaged in that conduct, how dangerous the conduct was, well, that's self-evident. How obvious was the danger, that's self-evident. Whether the conduct showed any regard for life, and all facts and circumstances. I don't see it, and I don't see it. Help me out where I'm going wrong.
Well, Judge, he was asked if he, not only did he, how he felt about killing them, but if he knew that his conduct would have killed him, and that firing that gun would have killed someone.
This element is on first degree, which is what we're not talking about, is whether he knew or was practically certain. And we're talking about reckless endanger or reckless homicide. So, I mean, to fire a gun 4 times into somebody, you don't think you'd know or have or be practically certain that that could have fatal consequences?
I would, but the defendant denied that it would.
He didn't. I didn't hear him deny it. He said he was protecting his own life. I thought he was. when he was being asked repeatedly, and correct me if I'm wrong, he was asked repeatedly questions along the line that you indicate, and he responded, I was trying to defend my life.
He was also asked the line of questioning, you knew if you shot 4 shots that you would kill him, and he denied that he would have that knowledge. So I mean, I agree that, I mean, I obviously think that it's utter disregard, because that's what we charged it as, and that's what we have presented to the jury, but I believe a reasonable jury and a reasonable juror could, based on the defendant's own testimony, not find utter disregard for human life. And that's the standard, not what we think, but what a juror could do.
I wish I knew the exact answers that were given. I'm not sure, and I when I say that, it doesn't mean I'm embracing your interpretation of what that would mean, but I would want to be sure exactly what was said anyway. So, are you able to identify when in the examination? Because you had a very lengthy examination.
Check my notes.
And, unless it's crystal clear, my suspicion would be if it turned out that the defendant would be acquitted, well, not acquitted, but if the jury returned a verdict on second-degree reckless endangerment with this description of what constitutes the crime, if they returned a guilty verdict over the defendant's objection, I would expect to be reversed.
On second-degree reckless endangerment?
Yes, homicide, I'm sorry.
So, you're saying if the jury finds the lesser
On this charge,
and the defendant objected,
over the defendant's objection,
and you accepted it,
right?
you felt it'd be reversed?
Yes. Unless you can come up with this crystal clear language that the defendant, and again, we're back to the circumstances of the defendant's conduct showed utter disregard for human life. So I think his thoughts on the subject would be relevant, would be a legitimate factor, but when I consider the others, what he was doing, firing into somebody 4 times, why he was engaged in it, there's dispute about that, but either it was it would certainly be reckless under any circumstances, and except under privileged circumstances. How dangerous it was, how obvious was the danger, and whether the conduct showed any regard for human life. And if anything, it seems to me he would have indicated, if you interpreted his answer, it would be an indifference. Although he did say at one point that he didn't want to kill anybody, but it would be an indifference, because when he's asked about his intent, what was the question you're saying again?
There was a line of questioning on if he cared about killing someone or cared in that regard, and there's a line of questioning is you knew that firing the gun could cause death, and I believe he denied or indicated he didn't know.
I don't remember that. Did
Everything that he said, I mean, the reality is everything was an intentional act. Now, they haven't charged it that way, and I appreciate that. But looking at the definition of utter disregard under the statute, I'm not going to repeat. I'm going to hold the same ground that you've already done. Firing 4 shots, we have evidence that the man grabbed the barrel of the gun. So we're talking about a distance of inches, not always feet, but in some situations, inches. It is the only logical conclusion would be that a person would believe that that conduct, if they were convicted, would show an utter disregard for human life. If self-defense isn't accepted, there's no other reasonable conclusion that can be drawn from firing a gun somewhere between 1 and 4 feet, all the way down to inches, by the soot on his hand. So I think that's what the evidence showed, and I think that's really the only evidence regarding the utter disregard portion of the statute. So
If the defense is willing to stipulate to the third element, then that's fine, we can go with that way, but it seems they're not arguing it, and if we want to go that way, then we can.
Conversations with lawyers are always interesting.
If they're not willing to stipulate, then obviously there must be some disagreement, or they must be trying to argue it, so I believe that there is a basis. I cannot recall at this moment precisely where in the cross-examination it occurred. Obviously it was lengthy, and I wasn't the one conducting it.
The examination, as I recollected, was that the defendant was repeatedly asked about the question about his thoughts on the subject of the death or survival of the target, and invariably responded that he was trying to defend himself and that he'd be killed if he didn't. And if anything, I would interpret it as an indifference towards the outcome with respect to the target, which is not identical to utter disregard.
Right, right. So if he's indicating he has an indifference, that would be second-degree reckless homicide.
And now it would be one factor, and I don't, even if I granted what, I just don't think it's appropriate. And I'll repeat my statement, if I were to give this instruction over the objection of the defense and the jury found a verdict on it, I would expect to be reversed.
Well, are we in agreement that element 3 is present?
Well, don't ask me, I'm not in a position to agree to anything. I'm not going to give that instruction. Or submit that verdict. 1345.